Let me ask you something. Have you ever thought that estate planning just sounds too expensive or too complicated, and so maybe it's something you'll just deal with later? Here's the thing most people don't realize. Doing nothing will almost certainly cost your family more money, more time, and more emotional stress. I'm Jennifer Nichols with J Nichols Law. I work with families here in Texas who want peace of mind when it comes to their future. Today, I want to discuss the actual cost of probate with you. I've seen too many families blindsided by the process when there's no plan in place. Let's walk through what probate is, what it costs, and how planning can help you reduce those costs. So, what is probate? It's the legal process the court uses to make sure everything in your estate, so your house, your money, and your belongings, gets passed along to the right people after you pass away. But here's the catch. When there's no will or no trust, or maybe just a poorly written will, probate becomes a lot more complicated and a lot more expensive. Let's talk about money, specifically legal costs. The cost of probate depends on the legal process necessary to transfer title of the decedent's property to the persons entitled to that property. It includes court costs, attorney's fees, and potentially some accounting and other fees. Court costs alone range from $400 to $1,000 or more, depending on the proceeding. Attorney's fees are on top of that, which constitutes the bulk of the cost. Attorneys typically charge hourly fees, that is a set hourly rate multiplied by the amount of time worked. An experienced Texas estate planning attorney typically charges from $300 to $500 per hour. Some attorneys charge a flat fee for uncontested services. At J Nichols Law, we offer a flat fee for most uncontested matters so that there are no surprises down the road. Attorneys dealing with a litigious situation, such as a will contest, may charge a contingent fee. That means they charge as their fee a percentage of the total recovery to you. In these situations, an attorney will typically charge from 25 to 40% of your share of the estate. If you don't have a plan in place, the cost to your family or other beneficiaries could be much greater. Without a will or trust, legal action may be needed to determine who your heirs are. This means additional court costs and legal fees. And if those heirs can't agree on an administrator, there will be significantly more legal costs. If you have a minor child as an heir, costs will be even greater. Maybe you have a plan and believe you have executed it properly. But if you didn't have an experienced estate planning attorney assist you, there is a good chance that probating your will be much more expensive. I have handled many probates for decedents with internet-created wills. Sometimes we have no issues, but more often than not, a legal formality was missed or there's an issue with interpretation of the will. If a formality, such as the use of a self-proving affidavit, was missed, the will becomes more expensive to probate. The will may lack the necessary language to create an independent administration, which will lead to increased legal fees. Moreover, online will templates use generic language, which may not fit your unique situation. If the language is unclear, your beneficiaries could end up fighting in court over what you really meant, which will cost more money. Holographic wills, which are handwritten wills, are also more expensive to probate. First, admitting the will to probate is more expensive because it requires special pleadings and the testimony of two witnesses familiar with the decedent's handwriting. Second, holographic wills often lack the necessary language for an independent administration. This creates the need for more court involvement, which drives up the legal costs. Finally, holographic wills often don't cover all of the what-ifs, such as who a particular asset should pass to, or what should happen if a beneficiary should predecease the testator. This creates the need to go back to the court to interpret the will, which is an additional expense. Finally, it has been my experience that wills drafted by attorneys who don't primarily practice in estate planning and probate often have mistakes. This leads to additional probate costs down the line. To avoid additional probate costs, I recommend that you hire a Texas board-certified estate planning and probate attorney to draft your estate planning documents. Now, let's talk about time. If everything goes smoothly, probate can take about 2 to 3 months. But if there's no plan or there's a dispute, it can take up to a year or longer. That's a long time for your family to wait, especially while they're grieving. The good news is you can avoid most of these problems. A well-drafted will or trust reduces the cost of probate and makes your wishes clear. I am board certified in estate planning and probate. I draft wills and trusts with the goal of accomplishing your objectives and reducing probate costs down the line. We offer flat fees for straightforward planning, so you know what you're paying up front. No surprises and no billing by the hour unless your situation requires it. If you've been putting this off, thinking I don't want to spend the time or money to draft a will, I'll just let my family figure it out, I hope you learned something from this video. If you're ready to start the conversation, we're here to help. Reach out to J Nichols Law. We will walk you through all of your options. Let's make sure your wishes are honored and your family is protected.